Britney Spears was 26 years old when her family started conservatorship proceedings in California due to serious concerns about her mental health. Fast forward 13 years and we see a 39-year-old woman seemingly trapped in a situation that may no longer be necessary. A conservatorship, or guardianship as it's called in Texas, can at times be necessary. But what was once a blessing may turn into a curse for a proposed ward. Hi, I'm Antoinette Bone, estate planning, probate, and elder law and guardianship attorney in the Dallas-Fort Worth Metroplex. And today I'm going to talk to you about how guardianship, while maybe a blessing when created, can turn into a prison, and how termination, while possible, can be difficult. So let's take a trip back to 2005. You may remember that a 22-year-old Britney Spears married 26-year-old backup dancer Kevin Federline. During their 3-year marriage, they had 2 children. Now, earlier that year, she had married a childhood friend, but that lasted a hot minute. Well, actually, 55 hours. But it was later annulled. Shortly after the birth of her second son with Federline, Spears filed for divorce at the tender age of 24 and ultimately lost custody of her children. She checked into a rehab clinic called Promises. In July of 2007, the divorce was final, and around the same time, Spears' financial assets were placed under conservatorship. Spears reportedly suffered from bipolar disorder and postpartum depression. Now, reports allude to a husband who would ditch her for his friends, leaving her lonely and abusing drugs. Media reports also suggest that she was surrounded by people who didn't have her best interests at heart and did things to contribute to her level of anxiety. A little family history shows a troubled home with an alcoholic father and parents who fought constantly. Then there was a pressure brought on by being a celebrity at a young age and having a relationship with a member of a boy band crash and burn in spectacular fashion in the public eye. There ensued a period during which Spears engaged in behavior described as erratic. This is when she had the meltdown and was involuntarily committed to a psychiatric facility. In 2008, Britney's father was named her conservator, which put him in charge of her finances. Now, there are conflicting reports about her relationship with her father. Some indicate her father was verbally abusive and enjoyed the control he had over his daughter's life. Others indicate that Britney depended on her father and they had a good relationship. Now, he served in the role as conservator until 2018 when he became ill and a temporary conservator was put in place. Now, Britney had sought to have a trust company appointed as a sole conservator, but the court only allowed the trust company to serve jointly with her father when he was serving. The trust company later requested to resign, citing Britney's desire to terminate the arrangement. As a conservator, her father had been able to control the spending of the money she continued to earn. According to a New Yorker article, since the establishment of the conservatorship, Britney has released 4 albums, headlined a global tour that grossed $131 million, and performed for 4 years in a hit Las Vegas residency. But her conservator controls her communications and personal decisions. On June 23, 2021, a hearing was to be held to discuss the arrangements of the conservatorship. Britney had requested the hearing. She wanted the hearing to be public, but the lawyers for the conservator wanted a closed hearing. Just before the scheduled hearing, Spears called 911 and reported herself the victim of conservatorship abuse. The transcript of that 911 call was sealed. Conservatorship abuse occurs when a conservator financially exploits or imposes excessively restrictive personal restrictions. In the hearing held on June 23rd, for the first time in years, Britney spoke on her own behalf during a 20-minute testimony. She described how she had been isolated, medicated, and financially exploited, and that she wanted the conservatorship to end. She described how she was forced to use birth control against her will, having had an IUD implanted. In a subsequent hearing on July 14th, the judge allowed her to fire her court-appointed attorney, who has represented her since 2008, and hire someone of her own choice. During the past 13 years, it's been the money that she doesn't control that is paid for the lawyers and the managers in her life. All the people that help to sustain the situation. Like the Texas guardianship process, the California conservatorship process requires an application, or a petition as it's called there in California, be filed seeking a guardianship, and that the proposed conservatee be served notice that a petition has been filed. The conservatee would be appointed an attorney to represent them. Now, California law required the proposed conservatee, Britney in this case, be given 5 days notice before conservatorship is established. But this can be bypassed if the judge determines the person would suffer immediate and substantial harm. In Spears' case, the judge granted the conservator's request to waive the requirement of giving her notice of the proceedings. Now, in Texas, we do have a procedure for speeding up the guardianship process, but even that process is going to take about 2 weeks. A person can seek to have a temporary guardian appointed. When that application is filed, a hearing must be held within 14 days. In Spears' situation, when she was involuntarily committed after the bathroom standoff in which she kept her youngest child instead of relinquishing him after a visit, now he was still a baby at the time, the conservatorship was in place within days. Based on statements from Spears and others around her, access to her children has been used to control her behavior and actions. Despite the possible nightmare a person suffering from a temporary crisis can find themselves in if they end up under a guardianship, there is a way out. However, it won't be easy. One of the most frightening aspects of what is going on with Britney Spears is that she hasn't been able to get counsel of her own choosing. She has tried on multiple occasions, but has been thwarted. In my video on what is a guardianship, I discussed how serious a guardianship is because of what happens to the ward, a loss of civil rights. Among losing the right to choose where you live and what medical treatment you receive and by whom, you lose the right to contract. The inability to contract is a significant hurdle in being able to hire a lawyer. By establishing a guardianship, the court has labeled you legally as incapacitated. This means you no longer have the ability to make sound decisions. Being determined to be incapacitated means you are going to have a difficult time hiring a lawyer who's going to require you sign an engagement agreement, a contract. If you don't control your own finances, it's going to be hard for you to pay that attorney. So it was a huge win for Britney when the court allowed her to hire her own attorney. Until now, she has not been able to effectively advocate for herself by being able to make the fundamental choice of who represents her in proceedings that have stripped her of her civil rights. One of the distinct aspects about this case is that it appears the establishment of Britney's guardianship or conservatorship seems to have been based upon mental illness, based upon what we see reported in the media. But in court documents, it appears that with the initial filing of the petition, documents indicated she suffered from dementia. The ugly side of guardianship is that it is somewhat of a self-perpetuating situation once it is put in place. If your incapacity is temporary, a guardianship can prove to be inescapable, which is why abuse can occur. Abusers in this type of situation tend to follow a pattern of isolation, medication, and liquidation of assets. When there are millions of dollars at stake, those in control have a financial interest in ensuring the guardianship continues. Most guardianships do not turn into this kind of living nightmare. Most guardianships are family members seeking to protect a parent whose mental state has deteriorated due to a medical condition like Alzheimer's or dementia, or a child born with a condition that prevents them from ever being able to take care of themselves. In these situations, guardianship is a blessing for the family who is responsible for the care and the proposed ward who truly can't take care of themselves. The guardianship keeps a parent from squandering assets by sending it overseas to some unknown person to pay the tax on a foreign lottery they have won despite never having been to the country, or from sending money to an online boyfriend who finds himself in dire straits. Tarrant County probate judges, where I primarily practice, are very mindful about ensuring they have a full understanding of the situation surrounding the application for the guardianship. Can a guardianship be abused? It absolutely can. Is that the norm? I don't believe it is. Can a guardianship be a blessing? It absolutely can be and often is. The bottom line is, wouldn't you prefer to be in control of your situation by naming people who you know and trust to be in charge of your money and your person if it became necessary to appoint a guardian? You can do this by engaging in some estate planning, putting in place powers of attorney and medical directives while there is no question as to your competence to manage your own affairs and make personal decisions. Having a robust power of attorney can go a long way in kicking the guardianship can down the road or avoiding it altogether. Now, not all powers of attorney are created equal, so you really do need to seek counsel of an estate planning attorney. Planning red flag. Beware. Estate planning is a process. It is not a transaction. Your relationships may change, and who you want to be in charge of matters can change. Therefore, you must keep your documents up to date to ensure they reflect a change in who you want to be in control of your affairs. When you no longer have capacity, it is too late to change what the documents say. In upcoming videos, I talk more about mental illness and guardianship and terminating a guardianship. In previous videos, I've discussed powers of attorney and medical directives. So make sure you check out my YouTube page. I'm Antoinette Bone, estate planning, probate, guardianship, and elder law attorney in the Dallas-Fort Worth Metroplex. If you found this content useful and would like to see more like it, please subscribe to my page, like this video, and don't forget to tell your family and friends. Thanks for watching, and I will see you next time.